welcome everybody. A very good morning to all of you. The topic of the day for today's webinar is personal guarantee, personal insolvency. Now, this is in fact, comparatively a very new subject. Even if we see from the perspective of insolvency law, that it has been recently introduced in late 2019, 1st December 2019. Earlier than that, we had all known about the guarantors who were corporate guarantors to the corporate debtors. The laws, the different, during the insolvency when it was introduced in 2017 onwards, the issue of corporate guarantors to the corporate debtors came up at various stages. Initially, it was thought that once the insolvency of a corporate debtor has commenced, the corporate guarantors cannot be proceeded against. Then came a judgment that no, if insolvency CIRP has been initiated against the corporate debtor, then the proceedings will not be initiated against the corporate guarantors. That view was taken by NCLAT in New Delhi in one of the cases. But later on, in SR Steel finally, and in one of the cases, NCLAT also said that the corporate guarantors to a corporate debtor get full absolved. They will be absolved from all their liabilities once the resolution plan has been accepted. That view was not accepted by the Honorable Supreme Court. In SR Steel case, they said that corporate guarantors or even the personal guarantors can be proceeded with, even if applying the clean slate theory, and if the resolution has already happened of the corporate guarantor, then also the corporate guarantors or the personal guarantors will not be absolved. Then the issue of the guarantors, because the issue of a personal guarantor being an individual came up for consideration. It was already under the stipulation, under the statutes also. It was being considered, and they formed a separate class because most of the promoters were also personal guarantors to the corporate debtors. There was a thinking going on that they were not getting, in fact, sucked in the entire insolvency process. And even though in many instances, they may be at fault or in default, their personal guarantee was basically, they were going scot-free. That was the reason, a rationale for including them and initiating and including them as a separate class in the personal guarantee, personal insolvency process. That is how the personal guarantors have now formed a separate class for initiation of an insolvency proceeding. From first, in fact, the sections containing this part 3 of the Insolvency and Bankruptcy Code, which contained the process of insolvency for the individuals, was notified on 15/11/2019. And various sections, individual sections were notified to have become effective from the respective dates. And finally, the provisions for personal insolvency was made effective from 1st December 2019. Immediately when it was notified, the same was challenged in the Lalit Kumar Jain case that is reported in now 2021 volume 9 Supreme Court cases page 321. The challenge was on various counts, that the provisions of section 2G, 2E, where personal guarantors were carved out as a separate class, was challenged. But it was all declared as intra-virus. And the making effective of the various provisions of the personal insolvency laws from various dates is also held to be intra-virus and within the competence of the legislature. So that issue now stands settled by the Lalit Jain case. And now the personal insolvency now has commenced, and it has come out with, it is more or less on the same lines as a corporate insolvency resolution process. Here we can say it is a PIRP instead of a CIRP. personal insolvency resolution process. The major distinction features, although it is almost similar, but the system is different. Because the concept is different and because the personal guarantors form a different and a separate class amongst themselves. Therefore, special care has been taken for them, and the resolution professional who has a role to play in a CIRP in the part 2 of the insolvency code also has to play a very major role in this part 3 of the code for the individual insolvency. Resolution professional here is more empowered and has a major role to play in the entire process of the insolvency process of a personal guarantee. The distinctive features, why the power is more, will come later on. But let us begin that the personal guarantor is defined under Rule 3E of the personal guarantee rules. Section 79, subsection 12 defines debtor, and personal guarantor has been defined under Section 5, subsection 22. It covers only individuals who are sureties to a contract of guarantee to a corporate debtor, and principal debtor must be a corporate debtor, a guarantor must be an individual. So 3 conditions have to be met. That personal guarantor has to be an individual. If he is a corporate debtor, he is a corporate person, and he is a guarantor to a corporate debtor, then he will be covered under the CIR under Part 2. But if he is an individual, then he comes under Part 3, the definition 5, subsection 22, as a personal guarantor. And then he must be a personal guarantor to a corporate debtor. And then it must, the guarantee must have been invoked. These are the 3 conditions under which a personal guarantor would become liable. Now, this being a new, in fact, process initiated almost from 2020 onwards only, because it has been introduced in December 2029 and 2019. So therefore, one of the major issues, and there are conflicting views which has come with regard to the jurisdictional courts. Who will be the jurisdictional court for initiating the insolvency process of a personal guarantor, personal insolvency? In this regard, Section 60, subsection 1 incorporates personal guarantor, and the judgments in NCLT and NCLAT have also concluded that even for if there is a proceeding pending for a corporate debtor, then for a personal guarantor, if the proceeding is initiated under Part 3, it will be NCLAT which will be the adjudicating authority. Now, Madras High Court has taken a different view by relying upon Section 179. In cases where the CIRP process has not been initiated against a corporate debtor, the debt recovery tribunal would be the adjudicating authority for a personal guarantor. But in one of the cases, in Mahendra Kumar Jajodia case, State Bank of India versus Mahendra Kumar Jajodia, NCLT has taken a view that even without any proceeding against a corporate debtor, or even without any CIRP proceeding, against a personal guarantor, the adjudicating authority will be the NCLT. So this view is yet to be settled by the Supreme Court because it has not gone up to that stage. But there are 2 conflicting views on the jurisdiction issue. Whether for the CIRP proceeding or without CIRP proceeding, who will be the adjudicating authority in the case of a personal guarantor. The process of insolvency resolution for a personal guarantor, it contains the section commences from Section 94 to Section 187 of the Part 3 of the code. here the issue is very, very different, because even the debtor who is a personal guarantor can be an applicant. Likewise, under Section 10, a corporate debtor who is in default can also file an application for his resolution. Here also, the debtor can also be an applicant under Section 94. But he can file an application all by himself under Section 94, Form A. But he can also file it through a resolution professional. The role of a resolution professional commences at the stage of making an application itself. Whereas the role of a resolution professional in CIRP proceedings in Part 2 would commence only after the application under Section 7 or Section 9 has been admitted by the adjudicating authority. Then only a resolution professional is appointed. Then there is the consent of an interim resolution professional, which may be confirmed as a resolution professional. Here, the resolution professional can be chosen by a debtor, individual, personal guarantor, and he can file it by himself or through the resolution professional himself. So that is one of the major distinctions between the CIRP proceeding and a PIRP proceeding for a personal insolvency. So, a resolution professional assumes a role, a very important role, right from the day when he files an application on behalf of the personal debtor. Similarly, Section 95 enables the creditors or a group of creditors to file an application for as against a personal guarantor. Here also, the creditors can file it by themselves or through a resolution professional. Now, one of the major here again, we pause here for a moment, because in the first part, as we have seen in Section 94, a corporate debtor, the personal guarantor can file an application under Section 94 by himself or through a resolution professional. So the role of a resolution professional starts from day one. Day one, even before the admission of the application, he files an application. Similarly, under Section 95, we have creditors or a class of creditors filing an application either by themselves or through the resolution professional. Here also resolution professional comes into picture from day one. Now here, another second major distinction here is that who are the creditors? Under Part 2 of the Insolvency Code, we have different classes of creditors, like we have operational creditors, we have financial creditors, we have other creditors. Here we have only the definition of a creditor. So we don't, for a personal insolvency, the categorization of creditors into financial creditor or operational creditor has not been made. That is one of the second major distinguishable feature so far as the personal guarantors are concerned. Under Section 95, a creditor is a creditor, whether he is an operational creditor or he is a financial creditor. Only one thing is that in the CIRP process also, the Part 2 also, and Part 3 also, the secured creditors have been put in a different pedestal. They have a better rights. They can claim themselves to be outside the purview of the process, or they can even join the proceedings. Here also, the third distinguishable feature for a personal insolvency is a notice by the creditors. A 14 days notice is given, and the debtor fails to pay. Then if a demand is given in Form B and the debtor fails to pay, then he becomes liable to be proceeded against under Section 95. The creditor can file an application under Section 95 or through the resolution professional. Now here again, there is a distinguishable feature. Here, in case of an operational creditor in CIRP under Part 2, a chance is given to a corporate debtor. Under Section 8, a demand is given by the operational creditor. And if the corporate debtor disputes the demand, or if there is a pre-existing dispute, the day when the notice is given under Section 8 of the Part 2 of the Code by an operational creditor, and the corporate debtor gives a reply, reverts the demand by saying that there is a pre-existing dispute, then that is a defense given to the corporate debtor, and the application under Section 99 would fail. Here, there is no such distinction. The creditors will only give a demand, wait for 14 days, and the application, Section 95. This is one third major difference. Now, therefore, after this, we come to the next major issue of Section 96 of the code, where it speaks about an interim moratorium. Interim moratorium would start on the date of application in relation to all the dates and shall cease to have effect on the date of admission of such application. So, interim moratorium would start when the application is made. It will end when the application is admitted. Then there is another final moratorium, which is under Section 100, which will start for a period of 180 days. So there are two different stages of moratorium, interim moratorium and a final moratorium. There in CIRP in part 2, we only have one moratorium. Section 14 is a moratorium which starts from the date application is admitted. Here, the moratorium starts from the date the application is made. Even before admission, the moratorium would start. Then we have Section 97, and which speaks about appointment of a resolution professional, the conditions which have been given, which, upon fulfillment of which a resolution professional can be appointed or replaced under Section 98. There is a provision under Section 98 for replacement of a resolution professional, which will be very, lot of disputes would come under Section 98 also, for various reasons. And one of the primary reason is Section 99 of the Part 3. A resolution professional makes an application under Section 94 or 95. And what are his duties? Because the day his application is filed, the interim moratorium starts. The resolution professional has been given very wide powers under Section 99 and then Section 100 thereafter, either to accept the application, he has to prepare a report. The resolution professional, Section 99 speaks that resolution professional shall examine the application referred to in Section 94 or Section 95, as the case may be, within 10 days of his appointment and submit a report to the adjudicating authority recommending for approval or rejection of the application. So he has to make a report within 10 days, either to approve the application or to reject the application. He has to make a recommendation to the adjudicating authority. Now, while doing so, he has a very major role to play. Suppose in cases where he approves the application is not for a resolution of the insolvency, the personal guarantor, but it is for the repayment, restructuring of his debt. Suppose he approves it. Then what is the process under which he will approve? There he assumes a very important role. That is provided for further, you will see, under (106). That one major departure from the earlier CIP, where the RP has a limited role of collation of all the claims and all, everything is here also. He will give a public notice, he will give a list of, prepare a list of creditors, everything do here also in Part 3 also. That is a mandatory condition. The process has to be followed. But what he does is, while approving an application for which has been filed by him for a repayment or a restructuring of the loan, he can not even summon the meetings of a creditor. Meaning thereby that without summoning the creditors, he can approve the repayment plan and file it. and give a recommendation to the adjudicating authority for approval of the application or for its rejection. Meaning thereby that creditors cannot even be invited by him. If they are invited, if he summons them, then their process has been given under section 106, 107, that he will give a notice, they will call for, then there will be a meeting of the creditors, and they will decide by a majority vote of 75% and above. So if the creditors are not called, and he decides upon a scrutiny that the application for repayment is all right, as according to him, and he recommends, that's a very major role given to a resolution professional, a very important responsibility given to him. And consequently, the adjudicating authority also can accept or can reject that approval application given by a recommendation given by the resolution professional. This is a very important role given to a resolution professional, and which will certainly be, it may be to the liking of a personal guarantor, not to the liking of the creditors, or it may be liking to the creditors, but because he has to take the consent of the debtor also while approving or giving an application for recommendation. So these are the major powers given to the resolution professional, which is much wider in part 3 than that given to him under part 2 of the code. Once the report is given by the resolution professional, what is the next stage? Thereafter, the adjudicating authority role will come into play, and it will either approve the resolution plan, the repayment plan, that is a recommendation of the resolution professional, or it may reject it. So it may either pass an order under section 99, either admitting or rejecting the application referred to in section 94 or 95, as the case may be. Now this again can be a trigger for the next stage. Suppose the application plan, the resolution plan or the repayment plan which has been recommended by the resolution professional is rejected. Then this becomes a trigger for the next stage, that is the bankruptcy of the personal guarantor. Or it can be accepted and approved by the adjudicating authority. So these are the two processes. Therefore, the first trigger here is, if it is rejected, it will give rise to a bankruptcy proceedings under the personal guarantor. Then the public notice is given by the resolution professional inviting claims from the creditors, just like in the CIRP proceedings under part 2. He will register the claims of the creditors. He will seek the consent of the debtor also here, and he will prepare a list of creditors in section 104. List of all the creditors. Then comes a very important section, which is under section 105 of the part 3 of the code, which speaks about a repayment plan. The debtor shall prepare in consultation with the resolution professional a repayment plan containing a proposal to the creditors for restructuring of his debts or affairs. Now, the debtor has to prepare a repayment plan. He has to give a restructuring of the payment terms in consultation with the resolution professional. And then resolution professional has two options thereafter. Without seeking or taking the advice or consent of the creditors, without summoning them for a meeting, he can accept and give a recommendation for approval of the repayment plan, or he can thereafter summon the meeting of the creditors, which is provided for under section 107 onwards. Then the creditors come into, their role comes into play. The percentage has been given that around 75% of the total voting rights has to be there for approval of the repayment plan. That is contained in section 109. Section 110 thereafter again gives a separate status to the secured creditors. They can join this proceeding or they can remain outside of it. Then section 111 says the repayment plan or any modification to the repayment plan shall be approved by a majority of more than 3/4 value of the creditors present present in person or by proxy, and voting on the resolution in the meeting of the creditors. So they have to approve it by a majority vote of 75%. After that approval, the same is presented to the adjudicating authority, and that order is to be passed under section 114. The adjudicating authority can thereafter reject the plan or can accept it. Now another feature is, suppose a repayment plan has been approved by the adjudicating authority and the period of the entire tenure of the repayment plan commences. If it is successfully completed, then there will be a discharge. If it is not, then under section 118, there is a provision that it will come to an end prematurely. The repayment plan coming to end prematurely. This again is very important because that will also trigger the next process of the bankruptcy against the personal guarantors. So we will come step by step as to what are the 3 triggers for the for the bankruptcy against the personal guarantors. Then the repayment plan is approved. There is the implementation provision is also there. Supervision of the repayment plan is to be done, and the resolution professional continues during this period also. Now, therefore, there are 3 triggers, the stages where the bankruptcy can commence thereafter. 121, the first is where an order has been passed by the adjudicating authority under subsection 4 of section 100. That is, when a recommendation has been given by the resolution professional or an application made, and the adjudicating authority rejects the application. That is the first trigger for taking it to the next part, that is the bankruptcy. That is chapter 4 of the part 3. The bankruptcy would commence thereafter. Then comes the second trigger. That is 115 subsection 2, when the adjudicating authority rejects the repayment plan under section 114, and the debtor and the creditors would thereafter be entitled to make an application under chapter 4 for the bankruptcy. And thereafter again under section 118, when the repayment plan comes to an end prematurely. So these are the 3 triggers for bankruptcy, and we don't have very many cases because many of the cases has all commenced very lately from 2020 onwards. So we don't have many cases under the bankruptcy of the personal guarantors. At this stage, we can only say that this is a very new subject and new topic under the insolvency law. And we all know that the case law is still developing in this. And we will have more and more cases and more clarity in subsequent months, in subsequent years. And as we all know that CIRP has become now the glamour of the litigation nowadays. It has gained momentum, and it actually has resulted in a lot of liquidity in the market. That is the primary objective of the insolvency code. Personal guarantee, therefore, personal insolvency, therefore, is a very different subject and a very new one. Not many cases have come under this, but still, These are the major distinguishing features of a personal insolvency as against a corporate insolvency resolution process. And we are at a very nascent stage. We are still developing. The law is still developing. The major issue of the jurisdictional court as to which will be the authority, whether it will be NCLT for all cases, whether for a corporate debtor which is going CIRP proceeding or against which a CIRP proceeding has already been initiated. Only those cases will be filed in NCLT and others will be filed before the DRT. That is an issue which is still not yet decided, but NCLT has said that even without a CIRP proceeding, because a personal guarantor, because in view of section 60, it speaks about a personal guarantor also an application in section 60, the jurisdictional court will be NCLT. So NCLT and the now recently Supreme Court has said that the constitutional courts like high courts should refrain from interfering or deciding or interpreting the specific law of the insolvency code. Because a special procedure has been adopted here, the NCLT adjudicating authority, then the appellate authority at NCLT, and then the Supreme Court. So that process may be followed, and somewhere the clarity will come, even if the high courts may take a different view. So this is in nutshell. Keshav, can you start the presentation from the first page, which I already said and given in fact a broad outline? Can you start with the pages which will demonstrate the sequence? Page 1, yes. Please come to page 2. Next page, yes. This gives us the dates. Please come to the previous one, Keshav. Yeah, this gives the dates of the different provisions under which the sections of the code and the rules for the personal guarantors were notified on 15/11/2019, and the provisions for personal insolvency were made effective from 1st December 2019. Please come to the next page. Here we have said about the Lalit Kumar Jain case, where the provisions which were made effective from 15/11/2019 were challenged in the Supreme Court. Now it has been held to be intravirus. Please skip, Keshav, 4 more pages, and come to the feature of the personal insolvency and corporate insolvency. Yes, it has been compared. Just, yeah, this place. Here, as you can all see, that the withdrawal application can be made 90% consent of the creditors. Because creditors are not categorized in the personal insolvency process, whereas in corporate insolvency, they are under different categories of operation creditor and financial creditor. It is not mandatory under the personal insolvency to constitute a committee of creditors or convene a meeting of the creditors, whereas it is mandatory under the corporate insolvency process. Here we have an interim moratorium and a final moratorium. There is no interim moratorium. The approval plan is by the 75% assent of the creditors, whereas in corporate insolvency it is 66% assent. There the next process is liquidation. Here the next process is bankruptcy. Yes, I'll come to the next page. Here, as we can see, section 5, subsection 22 defines a personal guarantor, and the 3 conditions have to be met. That he should be an individual. There must be a deed of guarantee, and the guarantee must have been invoked. And against a corporate debtor, the guarantee must be in favor of a corporate debtor. We'll skip. Next page. Next. Yeah. Here, as we can see, the jurisdiction issue has been touched. Section 60, subsection 1 and 2 speaks about NCLT being the adjudicating party. Section 179 speaks about DRT for cases where the corporate debtor is not under insolvency. That still is a view which requires to be there is a clarity. There has to be a clarity, and there is no final view in the matter because of the two conflicting views taken by NCLT, and then Honorable High Court Madras. Those views have been given in the next case. Bishop. The State Bank of India versus Mahendra Kumar Jajodia. Here the NCLT has taken a view that even if there is no CIP, the proceedings against a person cannot be dismissed on that ground. In Rohit Nath versus KB Hana Bank, Madras High Court has taken a different view. Next again. Now the process has been explained thereafter. Next, where we can start with section 94, which is an application by a debtor or by himself or through a resolution professional. There are three broad categories of debt, and its only exclusion is that it should not be an excluded debt under section 79, subsection 15. Then section 95, next page. Creditors, either by themselves or through a resolution professional, they can file an application by merely giving a 14 days notice. In CIRP, as we have seen, section 8 provides for 14 to 15 days notice there to the corporate debtor, which has the option of disputing it by saying it is a pre-existing dispute, which will bar section 9 application. Here, no such privilege has been given to the personal guarantor. Then withdrawal of application. There also the CIRP proceeding also it can be withdrawn. Next page. The distinction between interim moratorium and the final moratorium. And next page. And 4, the RP has to prepare a list of creditors. Then 106 is very important, which we have missed out here. It should be there between 104 and 107. That the RP thereafter can accept the repayment plan, give a recommendation, or it can reject the repayment application plan, even without summoning the creditors. 107, he has to convene the general meeting of creditors. The same provision will have to give a notice, and the creditors will have to convene and come as a meeting. Next page. The creditors will then have the option of approving by 75% of the creditors present and voting. Secured creditors have been left out. They have the privilege of keeping themselves, in fact, not joining the process. Then section 111, please come to the next slide. Next. Here are the features of the repayment plan. It is prepared by the debtor in consultation with the resolution professional. It contains the proposal for restructuring of the debtor's debt towards creditors, and the repayment plan must contain justification for the plan prepared, the reasons why the creditors agreed to it. The repayment plan can authorize the RP to carry the business of the debtor on behalf of his name. Like in CIRP also, the resolution professional assumes the management of the company. Here, the repayment plan can also give and authorize the RP to continue with the business of the personal guarantor. Next slide. 111 is the approval of the repayment plan. or its by acceptance in toto or by its modification by the creditors. 114 is the power of the adjudicating authority to approve the repayment plan on the basis of the report of the meeting. Next slide. So this 114 is the final culmination where the adjudicating authority either will approve it or it will reject it. If it is approved, the resolution plan will start and commence. The resolution professional will also have a role to play, and a time frame is given. And if it terminates prematurely, then it will trigger bankruptcy. And if it is not accepted or rejected by the adjudicating authority, then also the bankruptcy starts. So, next slide. So the application for bankruptcy therefore would arise. Next slide, please. Next again. Yeah, next slide after this. As you can see, there are 3 triggers for the bankruptcy. One is Section 100, Subsection 4. Another is when the adjudicating authority rejects the repayment plan by the meeting of creditors under Section 115(2), or if it comes to a premature end, the repayment plan under 118, Subsection 3. There are the 3 triggers for bankruptcy. Here in bankruptcy, under section, you can come to, I've given other presentations also on different slides, where the concept of bankruptcy is trustee has been formed. Please come to 126. Next slide. Next slide. Next. Yes. When adjudicating authority passes the bankruptcy order, within 14 days of receiving the confirmation and nomination of the bankruptcy trustee will be formed under section 125. Now, in the bankruptcy trustee, all the estate of the personal guarantor would be vesting. And then it can be thereafter divided. The resolution professional can also be a bankruptcy trustee, or some authority or agency can be made a bankruptcy trustee. And the estate of the personal guarantor vests into the bankruptcy trustee. So there is a new concept of a bankruptcy trustee has been formulated here in part 3 for the purpose of carrying out the bankruptcy order. By this we come to the end of the slide. Couple of pages thereafter, question is please come to bankruptcy estate. Yes. Here, what will include a bankruptcy estate and what will not include? It's provided for under section 155 of the code. So these are the broad outlook of the insolvency process for a personal guarantor. That is also viewed and taken as, or it is described as a personal insolvency. Keshav? Come to the end of the presentation.
Thank you, sir. Thank you. We have learned a entirely a new subject, which we have not dealt till date. And I have a question, sir.
Yes.
What is the, it is called as a death and imprisonment of a principal debtor. What is that, sir? Can you please tell me?
Referring to which case?
I have come across who can file. upon the debtor or death of a, when it can be filed, death of a debtor or imprisonment of a debtor. What is this, sir? Can you please tell me about
It is when a punitive action is for a personal misconduct is initiated, then there is a, yes, I will explain it.
Sir, please, sir.
I think it is given in the one of the pages in the.
Yes, sir. Yes. I have seen it.
Find it out where it is.
Sir, are we speaking about this one?
Yes.
Yes.
Yes, sir. Yes.
Situations during insolvency process that may arise.
Sir, please.
So even the death of the debtor will not, close the proceedings.
Okay.
It will continue against the estate of the debtor.
Sir.
It will continue with repayment plan will continue with respect to the assets of the debtor. That is what it has. It is merely in that respect.
Thank you, sir. Thank you. I got it, sir. Okay, sir.
That is a general principle also that the assets will be liquidated for the realization of the debt.
So, sir, once again, it was very enlightening, and I'm quite sure that everyone who has attended so far will need to refer to it again and again. And I received quite a few requests for sharing the link to this class later on also. So I will do that, sir, with respect to when we share it on YouTube in the upcoming weeks. So along with that, there are a few questions also which we have received so far. So very briefly, sir, just one other, I think, small doubt was there on behalf of Ms. Ajanta Gupta. Ms. Gupta, would you want to ask your question yourself?
Yes, sir. Sir, it's a wonderful presentation. Can you hear me, Keshav?
Yes. Ajanta, you're audible.
Okay. Thank you so much. It's a wonderful presentation, sir. It's altogether a new field and you have fantastically covered it with all the new case laws. And my question is, sir, in case the CRB process is going on or has been completed, and if the PG, personal guarantor, dies, can we initiate the IRP process against that person? In the bankruptcy proceedings, we have a provision that if it is bankruptcy proceedings has been initiated, that can be continued by the legal representative. But in the IRP provisions, we cannot see that. So is there any provision like, what can I see that? Can we initiate the IRP process against the personal guarantor if he dies? Even though the CRP process for that has been completed or maybe going on? Is there any way out?
Code is not very specific about it, but in my view, I think his assets can always be liquidated for that realization.
Under the code, sir. So we don't have to go to the another forums or the
not to another forum, because even when a repayment plan has been made and if the debtor dies, then
yes,
also
sir.
these assets can be liquidated.
Yes, sir.
So for the bankruptcy also the same, the provisions, I think it will continue against his assets.
And so I think but the white powers given to the RP about the repayment plan need to be looked upon, sir. It should be mandatorily consulted with the creditors committee, right, sir? If we propose any amendment, sir, what your point would be?
Creditors can because if he summons the creditors, then the creditors have the option of modifying it or
approving it.
But if he doesn't summon the creditors, because RP has been empowered for that.
Yes,
when
sir.
Without summoning the creditors, he can recommend. That is a very major departure from the CIRP, and it's very wide power given to the RP.
So maybe we need the amendments for such kind of provisions. What do you think, sir?
Maybe therefore I was referring to section 98, you see.
Yes,
that
sir.
The parties will move for replacement of the resolution professional for his misconduct and all those things.
Oh.
So the creditors can move an application for replacement of the RP if they are not happy with him.
Indirectly, there are repercussions. Otherwise, if he is not conducting the meeting.
That is a very wide power, because even without consulting creditors, if he approves a repayment plan which is not acceptable to the creditors, then what happens?
Sir. Right, sir. Perfectly, sir. Thank you so much. Wonderful presentation, sir. It's an opportunity to learn. Thank you.
Right. So, sir, first of all, once again, thank you so much for taking us so magnificently through this entire maze of IBC, actually, and that too on such a technical topic of personal insolvency. Sir, and we've any which ways we have taken more time than of yours than we had
No, no,
asked
no,
the
no
schedule.
difficulty at all. It's my privilege to be with all of you.
But that's
I'm
really,
very
really
delighted to be a part of this webinar. And I must thank Keshav for inviting me to the webinar. And we have done a very good work. And my endeavor has been to, give a brief, broad outline of the entire insolvency process for a personal insolvency. And I hope it has benefited.
Definitely.
Okay.
It has been pictured.
So, sir, it has been absolutely amazing and absolutely wonderful, sir, to to be able to have the opportunity and privilege to host you today. Sir, along with that, sir, we have another class right after this, which is by Mr. S.S. Nagananda. He is Senior Advocate, Karnataka High Court. So, sir will be speaking about the concept of Nishkam Karma and its relevance with respect to the legal profession, the nobility of the profession. And Nagananda sir has joined us. Sir, thank you so much.
It would have been
Once
my
again.
pleasure to be to continue to be here in the webinar and to hear him out. And Keshav, please do me a favor. Please give me a link so that I can, at my leisure, I will go through the entire presentation of Mr. Naganand.
Most definitely, sir. Most definitely. So we'll be sharing all of these classes on YouTube itself.
Yes.
It's our humble initiative, and it's actually entirely the blessings of our sirs, our gurus, who are here and who are kind enough to share such
We are
gems of wisdom
part of
with
the
us.
system. And anything we do, we have to see that the next generation, which is coming after us, should be, in fact, well equipped and more enlightened and more professional than us.
So it's just the guidance and the path that you have put upon us. And we hope that we will have the strength to walk on it and do justice to all of these efforts that so you have so generously put into us.